Good afternoon, everyone. Welcome to this lecture series on the rules on criminal procedure. This afternoon, we are going to discuss about Rule 117, motion to quash. So let me share my screen with you. Okay. Now, first, let us define what a motion to quash is. Motion to quash is a special pleading filed by the accused wherein before entering his plea, a motion to quash is filed, which will hypothetically admit the allegation of the information, and at the same time, it will set up a matter which, if duly proved, will preclude further proceedings. So a motion to quash class is filed before arraignment. No? It must be filed before arraignment or before the accused enters his plea. A motion to quash will hypothetically admit the truth. When you say hypothetical admission, the motion to quash will admit the truthfulness of the charge against the accused, but the motion to quash will set up a matter which, if proven, will preclude further proceedings, meaning to say the case will be dismissed. Now, a motion to quash is in the nature of a motion to dismiss. So what is the period to file a motion to quash an information or complaint? Anytime before the accused entered his plea, the accused may move to quash the information or complaint. There are certain exceptions. In instances where a motion to quash may be filed even after the accused enters his plea, if the ground for motion to quash is that the facts do not constitute an offense, or the facts charged do not constitute an offense. Second, lack of jurisdiction over the offense charge. Third, the criminal action or liability has been extinguished. And fourth, double jeopardy. So under the exceptions, the accused can still file a motion to quash despite entering his plea. Okay. Now the first exception, the facts charged do not constitute an offense. For example, the information will allege a series of acts or omissions which under the revised penal code or under the special penal law is not a criminal offense or is not a crime after all. Then even if after you have entered your plea, you can still file a motion to quash. Second, lack of jurisdiction over the offense charge. For example, the complaint filed is more than 6 years of imprisonment. If the offense charge is punishable with imprisonment for more than 6 years, then the jurisdiction is with the regional trial court. But assuming the prosecution filed the complaint before the municipal trial court or the first level court, then the court has no jurisdiction over the offense charge. Question: can the accused file a motion to quash even after arraignment? Answer: yes, because the court lacks jurisdiction over the subject matter of the offense charge. Now, third, criminal action or liability has been extinguished. For example, the prescription to file a complaint has already lapsed. Then the criminal liability has been extinguished. Therefore, even after the accused had already entered his plea, he can still file a motion to quash. And then the last exception is in case of the double jeopardy, when the accused is vexed or is being held to answer for an offense twice. So under the exceptions, you can file a motion to quash even after the accused had already entered his plea. Now, who can file a motion to quash? It is only the accused. The court may not grant the dismissal of a complaint without a motion filed by the accused. So the court is not authorized to file to motu proprio initiate a motion to quash by issuing an order requiring why the information should not be quashed. So again, without the accused filing a motion to quash, the court may not dismiss the case. Okay. What is the purpose of a motion to quash? Okay, the designated purpose of a motion to quash is to assail the validity of a criminal information, which is why, class, we said that a motion to quash is a special pleading. It is a special pleading because it sets into a question the validity of the criminal information. If the criminal information is not valid, then there can be no proceedings that can be had. Automatically, the court will have to dismiss the case even prior to the presentation of evidence. Why? Because a motion to quash will hypothetically admit the allegations in the information. So the accused is admitting, even assuming arguendo, that the information is truthful, there is a defense by the accused. If there is a lawful defense, then it's going to be a waste of time in order for the court to try the case. Because again, in a motion to quash, the accused is questioning whether the criminal information filed against him is valid or not. Now, what are the grounds under Rule 117 of a motion to quash? One, the facts charged do not constitute an offense. We have discussed this a while ago. This ground can be filed even after the accused had already entered his plea. No? Second, the court trying the case has no jurisdiction over the offense charge. This is already part of the exception. Third, the court has no jurisdiction over the person of the accused. Class, in criminal cases, how does the court acquire jurisdiction over the person of the accused? Number one, through voluntary surrender. Number two, through arrest. So if the court has not acquired jurisdiction over the person of the accused, say for example, there was an invalid arrest, okay? If there is an invalid arrest, then the court will not acquire jurisdiction over the person of the accused, and then the accused then can file a motion to question the jurisdiction over the person of the accused, or over his person rather. Now, for the officer who filed the information had no authority to do so. So we have discussed this, no, when we were discussing about prosecution of criminal offenses. Okay, there are certain officers who are only authorized to file an information in court. For example, not all prosecutors can file information in court. There are only designated prosecutors who can file the information in court. For example, the provincial city prosecutor or the city prosecutor, the regional state prosecutor, or the state prosecutor. So these are the only officers who have the authority to file an information in court. Now, what if the information has been filed by the deputy city prosecutor? Is the information valid? Answer, no. The information is not valid because under the rules on criminal procedure, only the city prosecutor can file an information in court. Now, what if the information has been filed by the deputy city prosecutor or the assistant city prosecutor? What is the status of the information? The information is void because it was filed by an officer who had not been authorized to file information in court. So the remedy of the accused there is to file motion to quash invoking paragraph 4 of Rule 117. That the officer who had filed the information had no authority to do so. Now, that the information does not conform substantially to the prescribed form, that more than one offense is charged except when a single punishment for various offense is prescribed by law. 7, that the criminal action or liability has been extinguished. 8, that it contains various averments, which if true would constitute legal excuse or justification. And then 9, that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without the express consent of the accused or double jeopardy. So Section 3, Rule 117 enumerates the different grounds for a motion to quash, and this enumeration is exclusive, meaning a motion to quash must contain any of these grounds, otherwise it will become unmeritorious. Okay. Now let us discuss them very briefly one by one. So when you say the facts charged do not constitute an offense, that means that the allegations do not constitute a crime, a criminal offense under the revised penal code or under the special penal law. Okay, jurisdiction over the offense charge, we have discussed this. So you have to look at the jurisdiction of the courts. So if a complaint has been filed in a court which has no jurisdiction over the offense or the subject matter of the offense, then the information is void. You can file a motion to quash. Or jurisdiction over the territory. No? Now, jurisdiction over the territory class, if the crime has been committed abroad, then Philippine courts will have no jurisdiction over the territory. Because class, criminal law is territorial in nature. No? Criminal law applies only within the Philippine territory, subject to certain exceptions under Article 2 of the Revised Penal Code on the extraterritorial application of Philippine criminal law. You say jurisdiction over the person of the accused. This is acquired again by voluntary appearance or voluntary surrender or arrest of the accused. Now, in determining the jurisdiction of the court in criminal cases, okay, you have to go to the extent of penalty for which the law imposes on the misdemeanor crime or violation of the law charge. So, okay. Okay. So let me pause first this recording.